Go back into trust and talk about it a little bit further here. This out of Solomon on jurisprudence. The creation and the extinction of corporations. Everybody talks about getting rid of the corporations. Corporations a beast. Well, this is what John Solomon, distinct jurisprudence, has to say. The birth and the death of legal persons are determined not by nature, but by the law. Again, the birth and the death of legal persons are determined not by nature, but by the law. All right? Are you a legal person? They come into existence at the will of the law, and they endure during its good pleasure. Curious, isn't it? Corporations may be established by royal charter, by statute, by immemorial custom, and in recent years by agreement of their members expressed in statutory forms and subject to statutory provisions and limitations. They are, in their own nature, capable of indefinite duration. Man, they can outlive God, right? This being indeed one of their chief virtues as compared with humanity. I guess that's why their vote counts more than yours. But they're not incapable of destruction, not even creative destruction, Koch brothers style. The extinction of a body corporate is called its dissolution, the severing of that legal bond which its members are knit together into a unity. We have already noticed that a legal person does not of necessity lose its life with the destruction or disappearance of its corpus or bodily substance. Right? There is no reason why a corporation should not continue to live, although the least of its members is dead, and a corporation's soul is merely dormant, not extinct, during the interval between two successive occupants of the office. What is this corporate soul? The king himself, however, is in law no mere mortal man. He has a double capacity. Remember yesterday, Sean called in and told us how much land the Queen has and claims ownership of, being not only a natural person, but a body politic. That is to say, a corporation's soul. The visible wearer of the crown is merely the living representative and agent for the time being of this invisible and underlying persona ficta, fictitious person, in whom by our law the powers and prerogatives of the government of this realm are vested. When the king is in his natural position, in his natural person, dies, the property real and personal, which he owns in right of his crown and as trustee for the state, and the debts and the liabilities which in such right and capacity have been incurred by him, pass to his successors in office, and not to his heirs, executors, or administrators. For those rights and liabilities pertain to the king, who is a corporation's soul, and not to the king, who is a mortal man. So we speak about the Queen of England, and then we talk about the crown, and then we talk about the crown and parliament assembled. Interesting stuff to me. The state is a corporation nation, everybody's looking at that these days. Of all forms of human society, the greatest is the state. The rise of statism is an all-out war between legal positivism and the natural law. That in the rise of statism, the state has arrogated unto itself all of that natural law. Back to the article here. Of all forms of human society, the greatest is the state. It owns immense wealth and performs functions which in number and importance are beyond those of all other associations. Is it then recognized by the law as a person? It is the commonwealth, the body politic and corporate, endowed with legal personality and having as its members all those who owe allegiance to it, pledge allegiance lately, and are entitled to its protection. This is the conclusion to which a developed system of law might be expected to attain. We'll find out more about that right after this. And so, inching forward with our understanding of what is the trust, why are they important, should we put our trust in them? What is the full faith and trust in the U.S. government? Huh? Right. Back to the article here. This is page 321 out of Solomon on Jurisprudence, the 12th edition. Important man, this John Solomon. Anyway, continuing, he says, but the laws of England has chosen another way. The community of the realm is an organized society, It is no person or body corporate. It owns no property, is capable of no acts, and has no rights nor liabilities imputed to it by the law. Whatever is said to the contrary is a figure of speech and not the literal language of our law. God forbid, right? How then are we to account for this failure of the law to make so obvious and useful an application of the concept of incorporation and legal personality? Why has it failed to recognize and express in this way the unity and permanence of the state? The explanation is to be found in the existence of the monarchical government, and the real personality of the monarch, who is the head of the state, has rendered superfluous at any rate within Great Britain, any attribution of legal personality to the state itself. Most public property is in the eyes of the law the property of the king, which word, since we are speaking of the sovereign generally, it is convenient to take as including the Queen. Like that? Most public property is in the eye of the law, the property of the king. Go up on the website and look at the Crown properties. Just type that into your browser and see what comes up for you. Makes it an interesting study, the Crown property. That's where all these offshore wind turbines, by the way, are being built over in jolly old. Public liabilities are those of the king. It is he and he alone who owes the principal and interest of the national debt. What do they mean? It's your share of the national debt. You go and look at the debt clock and your Congress whoer tells you what your share is. Oh, really? Public liabilities are those of the king. We could say the state. It is he and he alone who owes the principal and the interest of the national debt. Whatsoever is done by the state is in law done by the king. The public justice administered in the law courts is royal justice, administered by the king through his servants, the judges. His servants, the judges. His servants, the judges. The laws are the king's laws, which he enacts with the advice and consent of his parliament. The executive government of the state is the king's government, which he carries on by the hands of his ministers and his judges. Getting kind of religious on us here, aren't they? The state has no army save the king's army, no navy save the king's navy, no revenue save the royal revenues, no territory save the dominions of the king. Treason and other offenses against the state and the public interest are in law offenses against the king, and the public peace is the king's peace. The citizens of the state are not fellow members of one body politic and corporate, but fellow subjects of one sovereign Lord. You feel America? Feel like we got a king or a queen? Why did we revolt, huh? Did we ever get anywhere with that revolution? Is it time for Revolution 2.0? Here's a guy, La Follette. Some of you may know who La Follette is. Talk about La Follette here in a moment. Robert Marion, an American statesman, born in Primrose, Wisconsin, on June the 14th of 1855, died in Washington, D.C. in 1925, graduated from the University of Wisconsin, speaking of Wisconsin, in 1879. In 1880, he was admitted to the bar. He became a district attorney of Dane County in 1880, retaining that position until 1884 when he took up the regular practice of his profession. In 1867, he was elected to Congress, serving until 1891. He won reputation as an orator and as a member of the Committee of Ways and Means, took a prominent part in the framing of the McKinley Tariff Bill. At the close of his service in Congress, he resumed his practice and remained active in politics, becoming one of the leaders of the younger men in the Republican Party. Other causes championed by La Follette. Other causes championed by him include the workman's compensation, publicity of campaign expenses, the parcel post, the federal inheritance tax, exemption of cooperative farmers and labor organizations from the antitrust laws, women's suffrage, and the Seamen's Act. And he was one of the senators who opposed the arming of American merchant marine vessels in the European war zone, La Follette. Now let's find out a little bit more about him and why I bring him up. Going back to where we started yesterday, out of the History of Great American Fortunes by Gustavus Myers, open in front of me here on the table. These men, talking about the great magnates that lie in ambush, these men made much noise in the financial world and dashed around with prodigious belief in their invincibility. Sound like Goldman Sachs this morning, invincible? Too big to fail, right? They were vaunted as great financiers, doubtless inflated by their own success, wearing their $100 wristwatches. Talked about that company the other day. They esteemed themselves so and judged themselves fully able to cope with the great magnates. In the meantime, The Morgans and the Rockefeller Group was carefully observing their operations and awaiting the ripe time when they could be crushed out at one blow. The Standard Oil Company wanted those copper mines. Remember, Bahrain? I want to look it up. Bahrain used to be famous for its pearls. One of the greatest pearling places on the planet. Gave us the best pearls and the most pearls of any. Now pearls are just kind of set along to the side. Now it's the home of the Fifth Fleet, and it's a major export point for oil interests. They got a new form of pearls over there that they can string together. The Standard Oil Company wanted those copper mines, and the steamship company, organized by Morse, was considered a competitive menace to the railroad lines controlled by the Morgans and the Rockefeller interests. Senator La Follette, his account of the events that followed was accurate as to the facts. In his speech in the United States Senate, he gave this narrative. Now here it is. Suddenly, I'm quoting, suddenly, unless you think that this is crazy talk, centralizations in community control and industry, franchises, transportation, and finance, the panic of October 1907 and its lessons. It was a speech of Honorable Robert M. La Follette, Wisconsin, etc., on pages 21, 22, congressional records here. All right, this is right out of the record. Suddenly, here's the quotes, suddenly in the first days of October, somebody, to use a Wall Street phrase, began to smash United Copper on the curb. The stock broke badly. Standard Oil was getting underway. Doubtless, never suspecting the source, Hines, like Teresa Carey Hines, through his brother, a member of the stock exchange, and through brokers, bought and bought and bought until United Copper went out of sight, carrying down Hines's brother, one firm of his brokers, and involving the Morse-Hines banks in the crash. Up to this point, the panic had been well in hand. Again, this is October. Up until this point, the panic had been well in hand, but with the revelation following hard upon clearinghouse investigations, it slipped its bridle, and the situation assumed a serious aspect, but not for one moment did Morgan or Standard Oil miss the opportunity offered. Morse and Hines were forced out. They were compelled to reorganize their directorships and substitute semi-dependent Standard Oil men as their successors. They were forced to sell their stocks for what they could get. Morgan attacked Morse's Consolidated Steamship Company, stocks and bonds, and Morse was ultimately forced to surrender his steamship company, Combine, which he did. They went after the Knickerbocker Trust Company, Charles T. Barney, president, and close ally of Morse's. It was charged in New York that the interest deliberately started a run on the Knickerbocker Bank. Morgan was appealed to for aid. Morgan, whose plaudits have sounded right here in this chamber, was in a position to follow carefully every step and phase of this proceeding. In the first place, Morgan gave out, as reported in Wall Street, that the Knickerbocker would be supported if it met the demands of the depositors who had started a run upon it. There was nothing in subsequent events to indicate that there were any sincerity in that promise, but an analysis of every step is convincing to the country. Support was not given, it was withheld. After the company, relying upon that pledge, had paid out millions, it was forced to close its doors, and Barney went to a suicide's grave. The trusts, the power, and their influence.